Hello my dear learners. Today we are going to discuss nature of law of torts. After learning this module, we will be able to appreciate and understand the nature of law of torts and the liability in law of torts by differentiating between other types of liabilities like liability in crime, breach of contract, breach of trust, etc. The entire body of law is roughly divided into two branches. Number one is civil law and number two criminal law. Tort is a branch of civil law. The word tort is of French origin. It is derived from a Latin term tortum, which means twist, or it also implies twisted or tortuous conduct or crooked conduct or wrong, and in contrast to the word rectum, which means straight. In Roman law, it is also called as delict. Everyone is expected to behave in a straightforward manner. When one deviates from the straight path into crooked ways, he or she has committed a tort. In early period of English law, it was used as a synonym for wrong, but later it acquired a specific meaning which is much narrower than the ascribed to the word wrong. As a technical term of English law, however, tort has acquired a special meaning as a species of civil wrongs or injury. The exact scope of this branch of law is still unsettled because of the haphazard development through case laws and being still developing. All attempts to scientifically define it failed. Some writers gave up the idea of defining the tort, whereas some tried to define it, but no one could succeed in giving an accurate and scientific definition in order to ascertain the exact nature of law of tort. Salmon defines tort as a civil wrong for which a remedy is a common law action for unliquidated damages, which is not conclusively a breach of contract or breach of a trust or other merely equitable obligation. Tortious liability arises from a breach of duty, primarily fixed by law. The law imposes a duty to respect the rights vested in the members of society, and to that end, the person making a breach of duty is said to have committed a wrongful act. Tort is a breach of duty recognized under law of torts. Being civil injury, a tort differs from a crime in all respects in which a civil remedy differs from a criminal one. So, in general, tort means a conduct that adversely affects the rights of others. Law of tort is a branch of civil law which provides remedy or relief to the persons who have been injured due to tortious act. The nature of tort can be better understood by distinguishing between tort and other types of civil liabilities. The basic idea indicated in various definitions of tort is that it is a civil wrong, and secondly, every single wrong is not a tort, and there are other civil wrongs also, the important of which are breach of contract and breach of trust. In other words, we can say that tort is a civil wrong. This civil wrong is other than a mere breach of contract or breach of trust. This civil wrong is redressable by an action for unliquidated damages. Tort belongs to the category of civil wrongs. In case of civil wrong, the injured part institutes civil proceedings against the wrongdoer, that is the plaintiff, includes civil proceedings against the wrongdoer, that is the defendant. In such a case, the main remedy is damages. The nature of tort can be understood by distinguishing between tort and crime and other civil cases with a contract, a trust and a quasi-contract. Now we will try to understand the distinction between tort and crime. Although even today, in certain situations, the same facts may give rise to liability in both tort as well as crime. For instance, defamation is a tort and also a crime, yet the two differ in respect of both principle and procedure. The points of distinction which you might appreciate include: number one, as to the nature of interest. The interest protected by law of torts as well as crime is created by law. To that extent, both are alike, but the interest violated in tort is the interest of an individual, a person or a specific person only, while as the interest protected by law of tort is a public interest, and crime in fact is a wrong which affects the interests of rights of a public as a whole. As to the parties, in case of torts, the interest violated is that of an individual, and therefore suit is brought by individual whose legal interest is violated. In crimes, as you know, on the other hand, interest of society is also violated, and therefore state prosecutes the criminal. At least in theory, we would say that state is always a party to criminal proceedings. The person who commits tort is a tortfeasor or a wrongdoer, whereas the person who commits a crime is known as criminal or offender. As to the court, if you try to make a distinction between these two, in case of torts, a suit is filed in civil court by the injured party, whereas in case of crimes, the prosecution is noted in a criminal court and the proceedings are conducted in the name of the state. The distinction is not universally applicable. It applies only to those countries which provide for different set of courts for civil and criminal proceedings. As to the object, the distinction between tort and crime lies that the object of law of tort is to make the loss cast to the person whose legally created and protected interest has been violated by the wrongdoer, but the object of law of crimes is to maintain peace and order in the society and to eliminate crimes and criminals. While making distinction between law of torts and crime as to the proof, though the Evidence Act applies to both civil and criminal cases, yet considering the consequences of findings, standard of proof in criminal cases is more stringent than in the civil cases. In a criminal case, accused can be convicted only when the charge against him is proved beyond reasonable doubt. And if there remains a reasonable doubt as to his guilt, the benefit of doubt goes to the accused. He is entitled to acquittal. As to the remedy, as the object of two branches differ, the remedies also are different. The remedy in case of tort is a suit for damages, whereas in case of crimes, the remedy is prosecution and punishment of the criminal. Though there are certain provisions in the Code of Criminal Procedure empowering the court to order a convict to pay compensation, which is in the nature of unliquidated damages, yet in criminal cases it cannot be claimed in the first instance. It's ordered in addition to the punishment. Also, to compromise when we try to find out the distinction between this law of tort and law of crimes, the litigation in tort cases is compoundable. It means that plaintiff can withdraw a suit, whereas a criminal case cannot be compounded at all. However, under section 320 of Code of Criminal Procedure, it provides compounding of certain offences. Dear learners, now we will try to understand the difference between tort and breach of contract. A tort differs from a breach of contract in certain respects. Number one, as to the source of interest and duty. The interest in tort and corresponding duty are created by law, but in case of contract, they are created by agreement between the parties to the contract. As to the nature of duty, in tort, duty not to violate the interest of another person is towards persons generally. For example, when a driver drives a vehicle on the road, he has to take care of all other persons. This duty is not towards any particular person, but towards all the persons who happen to be on the road. In contract, on the other hand, the duty is towards the parties to the agreement and not towards any stranger. Mutual connection. When you try to ascertain the difference between law of torts and breach of contract, somehow there is the basis of making the differentiation or distinction is mutual connection. In tort, parties are usually previously unconnected, but in contract, parties may be connected through negotiation. And when we come to make a distinction between law of torts and at the same time breach of contract, privity of contract is here. In cases of contract, privity of contract is necessary, but in cases of tort, privity of contract is totally irrelevant. As to the rules of remoteness, remoteness in tort depends upon the foreseeability of the type of damage to the plaintiff. But in case of contract, the rules of remoteness are based upon proximity. Fault as the basis of making distinction between tort and breach of contract. In tort, fault in the shape of intention, negligence is usually necessary, except in case of strict liability. But in case of breach of contract, intention or negligence generally is immaterial. As to the nature of remedy, in tort, damages are always unliquidated, but for breach of contract, liquidated damages may be claimed where specified in the contract. Even where unliquidated damages are claimed, the principles of liability in tort and contract differ. In contract, damages are compensatory in nature, except in cases of contract of marriage, an action by a trader against his banker for dishonoring of his checks, while there is insufficient balance to his credit. In tort, on the other hand, exemplary damages may in certain cases be awarded by the court. Dear students, we will try to move and understand now the liability in tort and breach of trust. Breach of trust means failure to maintain trust property for the benefit of beneficiary by the trustee. Historically, the two branches have different origin and were subjected to different jurisdictions. For torts, action was brought in common law courts, but for breach of trust, remedy was given by the courts of chancery. So, tort owes its origin to common law of England, whereas trust owes its origin to equity courts. Though this connection is of no relevance today, yet the two branches can be distinguished in respect of remedies. In case of tort, the remedy is an action for unliquidated damages, but in the case of trust, the remedy is not for unliquidated damages. The claim is in general a simple debt. The measure of liability of trustee is the loss caused to the trust estate. The interest in case of trusts is also created partly by law and partly by parties. Dear students, if we now try to have a review of all what we tried to understand in this lecture, you can conclude that attempts have been made to define and explore the nature of law of torts, However, an absolute nature cannot be explored because of its inclusiveness. But nevertheless, explanations and definitions have brought into surface the nature of law of torts by distinguishing between the tort, the civil wrong, with other separate civil wrongs. From the whole discussion, it's clear that tort is a civil wrong. However, not all civil wrongs are torts. For example, breach of contract and breach of trust are civil wrongs, but they are not torts because their remedies exist in the contract itself. To determine a particular act as to whether it is tort or not, we must first make sure that it is a civil wrong. We should then make sure that it is not a breach of contract or a breach of trust or other civil liability, and the remedy is for unliquidated damages, or the remedy is unliquidated one. It can be said that tort is the residual of wrongful acts that are not crime and that do not fall under the contractual liabilities. Thus, if a wrongful act is neither a crime nor a violation of contract, it may fall under tort. The damages are unliquidated and are decided only by the common sense of the courts. With this, we conclude today's lecture on nature of torts. I hope you understood it well. Thank you.